All right, good morning. Welcome to today's webinar on Medicare Set-Aside. This webinar is hosted by Medical and Life Care Consulting Services, a case management and nurse consulting firm headquartered in Massachusetts. We're excited that you've joined us for this presentation. My name is 𝐔𝐬𝐿iggins, and I'm the moderator for today's webinar. This webinar is anticipated to run about 30 minutes with additional 10 minutes provided for questions and answers. Participant audio will be on mute throughout the duration of the webinar, and we ask that questions are submitted using the question and answer feature within the Zoom webinar dashboard. Post-webinar, we'll send an email with a link to a short survey and access to an on-demand playback of the webinar. Again, we're excited to host today's webinar and look forward to an opportunity to work with you. Let's get started. Our presenters are Cynthia Bourbeau and April Pettengill. Cynthia Bourbeau, President and founder of Medical and Life Care Consulting Services, has worked in Massachusetts as a registered nurse, certified rehabilitation nurse, certified nurse case manager, and certified nurse life care planner for over 3 decades. She founded MLCC in 2001, and the organization provides life care planning, Medicare Set-Aside, legal nurse consulting, and much more throughout the United States and internationally. MLCC also provides case management services throughout the Northeast region of the United States and a wide range of care consultation for catastrophic injuries. Cynthia is a member of the Association of Rehabilitation Nurses, the American Association of Nurse Life Care Planners, the International Association of Rehab Partners, and the Case Management Society of America. She is also a board member of the Certified Nurse Life Care Planner Certification Board. April Pettengill has over 32 years of experience as a registered nurse. She's worked in a hospital setting in geriatrics, pediatrics, telemetry, and orthopedics. For the last 29 years, she has been a case manager for work-related injuries and illnesses. Ms. Pettengill has extensive experience with catastrophic injuries, and in 2004 became certified as a nurse life care planner. In 2005, she expanded her areas of expertise by attaining the Medicare Set-Aside Consultant Certification and has been writing MSAs ever since. April currently works per diem for a local home health agency to keep her hands-on clinical skills active. While working in the community, she has had the opportunity to work with patients over the continuum of care, including high-tech pediatric patients. April is also a member of the AANLCP and has been since 2004. She's actively worked on the conference committee and most recently as secretary on the CNLCP Certification Board from 2007 until 2018. For today's webinar, our objectives include understanding the Medicare Secondary Payer Act, understanding the Medicare Set-Aside process and requirements and settlements, alternatives to the MSA, and to also discuss administration of the MSA. At this point, I am excited to hand it over to Cynthia Bourbeau.
The Medicare Secondary Payer Act actually started in 1965 when Lyndon B. Johnson signed the Social Security Amendments, which guaranteed a health insurance program for the elderly and disabled. It wasn't until 1980 the Medicare Secondary Payer Act was actually codified. The MSP guaranteed that health care costs for injuries could not be shifted to CMS. So the Medicare Secondary Payer Act is a collection of statutory provisions codified during the 1980s with the intention of reducing federal health care costs. It provides that CMS may pursue damages against any entity that attempts to shift the burden of medical costs to Medicare. In the Patel memo of July 23, 2001, the process for protecting the Medicare Trust Fund was outlined. It stated that Medicare's interest must be taken into account in all settlements where future medical care is included. It outlined the process and what should be included. So in 2004, CMS began enforcing the MSA, the Medicare Secondary Payer Act. Specific criteria for submission were outlined, and it required that all Medicare covered goods and services be included. Non-covered costs are not required to be added into the allocation. Costs should be by state fee schedule or usual and customary if no fee schedule is available. Longshore schedule is priced using federal fee schedule.
So, what is a Medicare Set-Aside Allocation? The Medicare Set-Aside Allocation is a document that specifies future injury-related medical needs and associated costs. Only Medicare-covered expenses are required to be identified. The set-aside has to include treatment that Medicare would normally cover, such as doctor's visits, physical therapy, equipment, medications. These identified goods and services need to be carved out or set aside away from the rest of the settlement and used specifically for those service costs. Effective October 2006, CMS is auditing both workers' comp and liability. So they're trying to be sure that if the MSA is not submitted to CMS, then the information is addressed in the settlement paperwork. Next slide, okay. In workers' compensation, CMS has formalized the process. It's kind of a secret in the industry that submission is not mandatory, nor is it required by law. There's no dispute with CMS about this, and its legal interpretations on the issue have remained consistent. In fact, a CMS representative actually testified before the federal court in Denver that this was the case. So the consequences of noncompliance can really be severe. Among these, CMS may deny the claimant future medical care. They could designate their own allocations, which may be as much as the entire settlement amount. This could be a counter higher, it could be a counter lower, or it could even take away services that were put in, or it could add in services that were not allocated. Another thing they can do is they can sue the claimant or the claimant's attorney and or the insurance carrier where double damages can be sought. In liability cases, the federal government did an audit in 2002 and found that there were more than $40 billion in legitimate and enforceable liens against claim settlements that did not contain approved allocations or did not take into consideration Medicare's interests. In 1995, there was a class action suit, USA versus Baxter International, which was a suit against the manufacturers of the silicone breast implants. During the appeals hearing in 2003, it was ruled by the 11th Circuit Court of Appeals that Medicare had a right of recovery for all medical expenses that they had paid related to the treatment of the breast implants. This opened up the door for Medicare to now begin to monitor liability settlements and start to issue conditional payment demands. So you still have to do a good faith determination in liability cases. So if the settlement includes costs for future medical treatment, that needs to be addressed. Medicare must be considered a secondary payer to protect the carrier from potential damages. In 2003, the 2003 memo stated that the MSA needed to be done in a subrogation case. If liability relieves workers' compensation, then MSA needs to be done. Enforcement and liability, as we noted, CMS has now been auditing settlements. So they started with the implementation of the recovery contractor. And they also implemented mandatory reporting, or Section 111 reporting. So this is where there's mandatory reporting of all Medicare beneficiaries, and we'll talk about that in the next slide. So mandatory reporting, or Section 111 reporting, became effective in July of 2009, and it mandated that the applicable plan had to report information to CMS when there was a beneficiary who was involved in a suit. So as you know on the screen here, it does not eliminate any existing statutory provisions or regulations. So it didn't change anything that was already in place. Who is an applicable plan? It means that that is the person who has the law, the plan, or the other arrangements, fiduciary or administrator of the plan in liability insurance, self-insurance, no-fault insurance, or workers' comp. So what must be reported, we'll talk about the specifics in the next slide, but basically it is the beneficiary, the illness, the injury, the incident, and the accident that's at issue. And then that information is used to do the coordination of benefits for any applicable recovery claim. So it's reported in a manner specified by the Secretary, and Secretary is capitalized because it is the Secretary of CMS. The information is submitted in a specified time frame, which in this case is every quarter. After the claim is resolved through settlement, judgment, or award, or other payment, it must be reported as well. All submissions are done in an electronic format, and it's done through a portal. Okay, next slide. So the specific information that is reported are the demographics as you see here. There's also the primary plan type. So in other words, if it's workers' comp, liability, no fault, auto, that needs to be included. Very important is the ICD-10 codes for the body parts need to be reported. This is the driver for what gets put on the conditional payment information. So if the wrong information is put into the reporting, then you get mixed information on your conditional payment statements. Upon resolution of the claim, the settlement date must be reported, the amount of the settlement, how the claim is being resolved. In other words, are there contested parts? Is there any ongoing financial responsibility, and the funding? So that could be lump sum, it could be an annuity, and that needs to be made clear to CMS. Expectations, we can expect more memos as this process becomes more defined over the next few months. Third-party liability MSAs are being discussed, and in fact, they have now opened up another round of advanced notice of public comments to discuss what potential liability MSAs might look like. They can also make this all retroactive. So it's very important to start to think about Medicare in your current settlements and how are you going to deal with that. Okay, next slide. So the SMART Act of 2013. SMART stands for Strengthening Medicare and Repaying the Taxpayers Act. It actually was initially introduced in 2011 and was passed by the House and the Representatives, or the House and the Senate, in 2012, and it was signed into law in January of 2013. Why this is important is because it added a discretionary element to the civil penalties for non-reporting under Section 111. As it stood initially when Section 111 reporting came out, it was a $1,000 a day penalty. This SMART Act allowed for that penalty to become discretionary. It also expedited the conditional payment demand. So prior to this, if you wanted the conditional payment, you put in a request and then you waited and you waited and you waited, and you might get it in 3 months, you might get it in 6 months. You might have to re-request it because they lost the payment or they lost the request. So now they have very specific timelines when they have to send out the conditional payment responses. You can actually go onto the portal and get the conditional payment information as of that day. They also added an appeal process, which the government, of course, always has different terms for these things, and they call it a re-review process. So it doesn't pertain to all MSAs that are reviewed. Very specific criteria needs to be met before an MSA can be re-reviewed. It also limits the time frame against claims or claims against plans and beneficiaries. And they're supposed to also stop using Social Security numbers or health insurance claim numbers, or, which are basically your Social Security number. Okay, so now that we know that we have to do an MSA or take Medicare's interests into account, the next step is to develop the MSA or the Medicare Set-Aside Allocation. This is a report that addresses the Medicare covered goods and services that needs to be submitted to CMS to their benefits, the Coordination of Benefits Center. It must summarize the injury, what parts are covered, the previous care, medications, and the anticipated future care and costs. You also need to identify the conditional payments for the settlement. Along with the MSA, what is submitted to CMS is a submitter letter, which is a basic, shortened version of what has happened, includes demographics and ICD-10 codes and that type of thing. The consent form is very important that the consent form includes everybody who is to get a copy of the CMS response. If there's a rated age, that needs to be included, or full life expectancy if no rated age is sought. The life care plan, if there is one, settlement agreement or proposed settlement agreement, or any court order regarding settlement needs to be included. If there is none, that's fine. The administrator, if it's going to be professional, then a copy of the agreement needs to be in there. Medical records, payment histories, including pharmacy, needs to be sent, the allocation report, and then any supplemental or additional information. And that could include things like any court orders or upheld, denied body parts, anything like that. Okay, next slide.
When is a Medicare set-aside allocation reviewed? These are review thresholds and not a safe harbor. So a workers' compensation MSA is reviewed by CMS in two different situations. One, when the claimant is currently eligible for Medicare and a total settlement amount of greater than $25,000 is identified, or when the claimant has a reasonable expectation of Medicare enrollment within 30 months of the settlement date and a total settlement of greater than $250,000. Medicare's interest must be taken into consideration in all settlements. And when a claimant is currently Medicare eligible, an MSA must be completed regardless of the settlement amount. The computation of the total settlement amount includes, but is not limited to, wages, attorney fees, all future medical expenses, including prescription drugs, and repayment of any Medicare conditional payments. Also, any previously settled portion of the workers' comp claim must be included in computing the total settlement amount. No safe harbor means that Medicare's interests need to be considered for every beneficiary if the settlement includes money for the future medical care. These are only for when CMS will review the MSA. If you send it in and it doesn't meet these, then you'll get a letter back saying thanks, but will not review it. Next slide. How is the MSA developed? Information is provided to the company who will be developing and submitting the MSA. Specific information is required, and conditional payments also need to be identified. Medical records for the last 2 years of treatment are reviewed and summarized. Future medical care is determined based upon CMS guides and coverages, and then priced per the workers' comp fee schedule or usual and customary pricing. CMS developed a WCMSA reference guide that is available online. It goes through the entire process and the requirements. The submitter sends the document to the referral source, and if all parties agree, then it is submitted to the contractor to review. Next slide.
So who is qualified to develop a Medicare set-aside? According to Medicare, anyone can develop an MSA. However, in an attempt to provide some training for qualified people to be able to do this appropriately, the Medicare Set-Aside Consultant Certified was developed. This includes training that has 30 hours of time related to the Medicare Secondary Payer Act. Then you have to pass a national examination. To be able to sit for this exam, you also have to have a professional experience, including 12 months of full-time employment within the last 3 years in the industry discipline, such as workers' comp or liability insurance. So people who qualify this could be nurses, life care planners, insurance claims adjusters, and attorneys. So as I noted, once you complete the course, you pass the exam, and then you have to have continuing education of 15 hours for every 3 years to be able to maintain that certification. So the end result is basically you have people who understand Medicare's regulations, the care, the coverage issues, and it protects you and CMS that the set-aside has been developed appropriately. So after the settlement, what happens to the MSA? The money, first of all, needs to be put into an interest-bearing account. Then it's used for the items in the MSA that Medicare would normally cover. The money cannot be used until the person is on Medicare. An annual accounting summary must be submitted to Medicare, and this can be done either by the recipient or the beneficiary or by a paid administrator. If the money is not used up during that year, it is rolled over into the next year if it's an annuity. If it's used up before the end of the year, then Medicare will pick up any injury-related costs. Once the money has been totally exhausted, then all injury-related care can be covered by CMS. Something to also consider is the death of the injured party. The only guidance that Medicare has provided in regards to this is that the money is distributed according to settlement documents or state regulations. Of interest is sometimes insurance companies will put reversionary statements into the settlement documents. So upon death, that money goes back to the insurance company and doesn't stay with the estate or distributed according to the settlement. So MSA administration can be done a number of ways. Self-administration is when the beneficiary is responsible for paying the bills, making sure that the providers understand that it's paid according to the fee schedule or however the money was distributed in the MSA. The other option is professional administration, where you pay somebody to administer the MSA. There are three types of administration available. One is a full custodial, where the money is sent to a company. They do everything. They receive the bills. They negotiate the fees. They send in the annual paperwork to CMS. Everything is handled in-house. Typically, they set up medical accounts to do that. There's also self-administration support, where you have a professional administrator help someone who is trying to learn how to do self-administration. This is typically short-term, like maybe a year, maybe on an as-needed basis. So that is usually just a short-term thing. There's also the Medicare Secondary Payer Charitable Foundation, which was set up a few years ago, and it's free administration. However, upon the death of the beneficiary, the money stays with the foundation and doesn't go back into the estate. So if you choose that route, be very cautious of that, that criteria. So there are some other options as opposed to formalizing your MSA and submitting it to CMS. It's not, remember, it's not mandatory, nor is the submission mandatory. So some of the alternatives are to what we call paper the file with a non-expert opinion. This would be just a guess at what the future medical care might cost the person. You can also do the MSA, put it in your file, put the information in your settlement documents, but not actually submit it. There's also what we call medical savings accounts, where the money for future medical care is put into a savings account, typically like a CD or a long-term type of annuity. So those are some options for that. Do these cover you? Do they cover the clients? If you're using a non-expert opinion, you have to prove that Medicare's interests were reasonably considered if you are ever audited. It may be difficult if you don't have any official documentation. If you have an MSA that is completed, it's in the file, it's available, everyone can see it, it can be used as a roadmap for the person. Medical savings accounts may be a good option in terms of people who have access to other ways to pay for the treatment and then get the reimbursement from the account when the money becomes available.
So the takeaway, Medicare's interests need to be considered in all settlements. MSAs are not required, and they are not required to be submitted. Conditional payments, liens, need to be resolved. You need to report the final settlement and then consider the type of administration you want to do.
Fantastic. Thank you so much to both Cynthia and April for such good information. Before we hop into our question and answer segment, we'd like to point out the services that MLCC provides and also remind you that all case consultations are free. So if you have a question or you want to kind of get some insight on a case, we'd be happy to assist you. Please feel free to jot down our contact information and call us. MLCC also provides medical chronologies, medical cost projections, life care plans, and legal nurse consulting. Now, we're going to go ahead and hop into our question and answer section. So please feel free to use the chat or Q&A feature within the Zoom dashboard, and we will host about 10 minutes of Q&A. All right, so we've already got one. I'm going to share the question and either of you guys can respond. So if the person has not treated in the last 2 years, what do you need for documentation?
Okay, so the guideline says that you need the last 2 years of medical records. Now, if they're not in the last 2 calendar years, that's okay. So let's say the last time they went to the doctor's was in 2006. You will need 2006, 2005, 2004. I mean, obviously that's a long time ago, but you get the idea. So the last 2 years of treatment is what needs to be provided.
Thank you. We have another question. What if surgery has been mentioned, but the person does not want to do it? How is that handled?
So again, it depends upon how long ago the surgery was recommended and whether or not it has continued to be recommended. If it was a one-time, yes, they may need a surgery, and then it was never mentioned again for the next 2 years or the next 3 years, then you're probably pretty safe not having that in the MSA. If it's something that keeps coming up over and over and over again, but the person is choosing not to proceed with that, or they have comorbidities that potentially make it difficult for them to proceed, then that needs to be laid out in the MSA very clearly in the narrative portion. Sometimes also getting a statement from the provider or from the individual indicating they're not wanting to proceed with surgery, that can also help to not have it put into the MSA.
Thank you. All right, we have time for a few more questions, so please feel free to use those chat features to submit them. Here, we got another question. I have heard about zero set-asides. Can you explain what those are?
Okay, so a zero MSA is where there's no future medical included, but for some reason you're looking for approval from CMS to say that none of the future settlement will be for Medicare-related goods and services. Typically, this is not upheld very often by CMS unless you have a very strong denied conditions situation. So if it's a denied claim and the insurance company has never paid for any treatment for anything since the beginning of the claim, then that's a pretty strong condition for a zero set-aside. If the person has had treatment and it's been paid for, but they haven't treated in a really long time, chances are you're not going to get a zero set-aside approved. CMS will put in, or the contractor will put in, some treatment for the future with the idea that the person may get exacerbations or they may have treatment that needs to be done in the future as they age.
Thank you, thank you. So it looks like that's all the questions that were submitted. We would very much like to thank the participants for joining us today. We hope you found this webinar and the information shared to be insightful and useful. And as mentioned, we welcome your calls and consultations. Additionally, I'd like to thank our presenters, Cynthia Bourbeau and April Pettengill. You did an amazing job. And I thank you again for your time. This concludes our webinar. Goodbye.